Okay, so good morning, everyone. Thank you for joining AIS seminar today. Today, we will talk about legal affairs. And then, like last time in September, the different seminar, today we will do also in hybrid seminar. So, those who you are here, you can hear also and ask the question directly to the speakers. Actually, she's coming later. And then for the Zoom speaker, in the Zoom participants, they can join here. And then I see now more than 10 people are here. So let's start. And then today, we will talk about also the Japanese business situation and also the JETRO's service. Today we have a special guest. Then let's see. After I finish this introduction, I give the floor to the Nina. She's JETRO Warsaw. JETRO is a Japanese government-related organization, also to promote the business between Japan and overseas business in terms of the trade and investment. And then the JETRO, they also support Estonian companies, those companies that are willing to invest Japan, investment at the open office, and then be active in the Japanese market. And then after Nina, today's main speaker, Ms. Yuri Shibahara, she will come in 10 minutes, and then she will talk about the legal affairs. She was, before she moved in Estonia, she was in Japan and engaging in the corporate legal affairs, and then supporting some of Estonian companies that enter the Japanese market. So today, you can also ask a lot about the legal affairs. And then when it comes to legal affairs, of course, those companies who actually already establishing company in Japan, but also for Estonian company who try to find a partner in Japan, and then sometimes you might face the situation where that you have to sign NDA or some kind of agreement, MOU. So in general, I believe that the Japanese people are honest and nice people, but not every Japanese are so. And then of course there are some issues also happen sometimes. So yeah, please be careful that, and then you have to always do the background check of the partners before entering any contract with them. Okay, and then today we are planning to close this seminar at 1 o'clock. And then today also we record this webinar, and then later on you can watch as well. So those who have to rush to somewhere, then yeah, you can leave also. And then introducing about the AIS, this Asia Kesks. In Estonian, it's called Asia Kesks, but in English, we call this Asia Trade Agency. So here is the team. So the Eva is the head of the team, and then I am in charge of the Japan. And then Rafa and Ilaria, they are in charge of China. I guess you might have seen them. And then Grace and Vinod, they are in India market. And then Johanna is in charge of the Southeast Asia, and then Crystal is in Singapore. And then left side, these 4 people are in Tallinn, and then the right side, they are in those countries. Ilaria in Beijing, Vinod in Delhi, and then Crystal in Singapore. And then now we are planning to hire the Japanese export advisor in Tokyo. So after we hire this Tokyo person, then we can offer you better service as well. Regarding the service, that what we do. So if you go to this Asia Kesks website in AIS, you can see. So you can ask questions to us, inquiries free of charge, and then we also do background check. So those of you who meet some potential companies, then we can check the background of the companies and then give you more information. Because in Japan, unlike Estonia, that this corporate information is not so transparent. Sometimes only available in Japanese. So yeah, before discuss the detail with the partners, please talk to us first. And then we also provide a market report, which consists 10 to 15 pages. This is it costs €300, but we make based on your preference. So if you prefer, if you would like to know some of the numbers, for example, number of retail stores, number of sales channels, and then those things that we can provide. And then after we recruit the Tokyo advisor, we can offer for export partner search service. This is a service that it costs €500, that we will find the 5 potential companies for you and then set up meeting. And then also we will provide a brief summary of the market. So this one at the moment, because of the COVID situation, we offer at half price. For China, India, and Singapore, we already offering this service. So if you are interested in the export partner search service in those countries, you can contact those advisors directly. For Japan, I promise that we will provide soon. Okay. And then yes, and also if you have any question, just any question that related to the Japanese market or Japanese companies or like a Japanese economy or COVID situation, just let me know. These questions that I can also handle daily basis, and then it's free of charge. Yep. So yeah, if you have any question, and also you can, if you want to know more detail, you can go to this website and you can click each service link. Then you can see the detail. Yes, because for example, if you would like to order the market report, then you have to officially send email to AIS general email, and with your preference and so on. So far, do you have any questions? No, you know this already. Okay, so now I will give floor to the Nina. Let's check. Nina-san, can you hear?
Yes, I can hear you. Can you hear me?
Okay. Yes, very clearly I can hear.
Okay.
So I will stop sharing so you can share screen.
Okay.
Yeah, and then so the Nina-san is she's based in Warsaw, Poland, and then working in the JETRO, as I explained before. And then JETRO is, as I said, the Japanese government agency, and then the Warsaw office is covering this Baltic region. And then also I am also supporting JETRO, and then if JETRO requests, then I am working, and then I am meeting the Estonian companies on behalf of JETRO. So yeah, I've been working with Nina-san almost 3 years. So okay, Nina-san, then can you share screen?
Yes, I will try. Just give me a second. Can you see it?
Not yet.
Wait just a second. How about now?
No.
Now you can see it?
No.
I'm sharing the screen. I'm not sure what's going on.
Yeah, I think now I can see your desktop.
You can see my desktop, yes, okay. And now?
Okay, good.
Okay, great. So good morning once again. My name is Nina, and as already Mr. Yoshito has introduced me, I'm a research and products coordinator at JETRO Warsaw. Today I'd like to tell you about the business environment in Japan and JETRO service. So let's get started. So Mr. Yoshito has already briefly introduced JETRO, but let me just say a few more words about our organization. It's a governmental organization. It's dedicated to enhancing bilateral trade relations with Japan. It was established over 60 years ago, and now we have 74 overseas offices in 54 countries, and the number of them is increasing. In addition, we have domestic offices throughout Japan, which enables us to effectively cooperate with local governments and companies. And our Polish office is responsible not only for supporting Polish companies, but also for Estonian, Latvian, Ukrainian, and Lithuanian market. Recently, our activities are focused mainly on supporting foreign companies who want to invest in Japan and on promoting trade and technology cooperation between our countries. Now let's take a closer look at the plan of today's presentation. I think it's quite packed with information. It will be divided into 4 main sections. And first of all, I'd like to share with you some information regarding Japan's business environment and economic condition in the light of COVID-19. Then I present what's the status of FDI in Japan and what has been done to enhance them. And finally, I'll explain how JETRO is supporting foreign companies that are aiming to enter Japanese market. So let's talk about Japan's economic condition and how was it impacted by COVID. Japan is ranked 3rd in world ranking of GDP. So it's one of the biggest and most attractive world economies. And due to problems with aging society and low birth rate, Japanese economy is expected to shrink. However, it was still expected to keep top 5 rank in 2050. With the impact of COVID, the global economy long-term estimates are likely to be adjusted, but we still hope that Japan will keep its top 5 rank. So Japan as a country's economic power, but also its local regions have a national level GDP. So for example, as you can see, the GDP in Kanto area, which includes Tokyo, is almost the same as Brazil's. And GDP in Kinki area, which includes Osaka, is similar to Switzerland. So although Tokyo is considered to be the most attractive business area in Japan, and about 70% of foreign companies is located within Tokyo area, well, it's apparent that each region has strong economy and can be considered an attractive business destination. Although the speed of Japanese economic growth has not been rapid comparing with other Asian developing countries, such as China, but for the last few years, it has been rather stable. As you can see, in the 4th quarter of 2019, the Japanese GDP has fell rapidly. It was due to the consumption tax introduction and the rise of, and the decline in consumption which followed. It was expected to be a temporary recession, and in the 1st quarter, everything seemed to be back on track, but then COVID-19 struck, and Japanese economy fell sharply throughout the 2nd quarter of 2020. Fortunately, the forecast is not so bad. In 2021, the worldwide economy is expected to recover, and Japan is no exception. So now let's take a closer look on the condition of companies in Japan. As you can see, regardless of industry or company size, the business conditions deteriorated significantly. In the end of the year, the situation has gradually improved, but still has not returned to the pre-corona level. Foreign companies have also been affected. According to the survey conducted by JETRO in April and July 2020, more than 90% of companies responded that COVID had a negative or slightly negative impact on their business. We've asked companies how long it would take them to recover, and until the 1st half of 2021 was the most popular answer. However, despite the large number of companies negatively affected by COVID, most foreign companies will continue doing business in Japan. In the survey, the vast majority of respondents are positively planning to expand or maintain their business in Japan. while only less than 10% would downsize or withdraw their business. Which brings us to the next section of my presentation, which is the Fdi status in Japan. In 2019, Japan became the largest global investor for the second consecutive year. However, at the same time, in the inflows of FDI, Japan ranked only 15th. And the truth is that Japan for years hasn't been considered an attractive FDI market. This is exactly why the Japanese government has been strongly supporting the Invest Japan program run by JETRO. As you can see in the slide, in results of the government strategy, the investment stock in Japan has been steadily increasing and reaching a new high for several years in a row. So what companies invested in Japan? As you can see, Europe accounts for the largest total investment stock in Japan. However, in the last few years, the proportions have been gradually changing. While the Europe share has been decreasing, both North America's and Asia's have increased. The graph to the right shows that although companies from around Europe have invested in Japan, but looking by country, US is #1 Japan investor. Its stock is almost twice larger than France, which comes second. As far as the flow of FDI in Japan is considered, investment from North America was the largest. Asia made the second largest flow by region. On the other hand, investments from Europe decreased significantly. Also by country, US is yet again the largest investor to Japan. The country alone accounted for almost half of the total FDI flow to Japan, leaving UK, the next largest country, far behind. In the view of the impact of COVID, it's expected that the global inward flow of FDI will flow. However, according to JETRO's survey, many companies continue to have high expectations regarding the growth potential of the Japanese market. So where do they see the investment potential? I've already mentioned that Japan is world third economic power, but it's scoring high in several other rankings like FDI Confidence Index. So no doubt it can be considered a highly attractive market in many aspects. However, in Doing Business 2020 ranking published by the World Bank, Japan ranked 29th overall and 8th among G20. So no doubt there's room for improvement. As you can see from the graph to the right, some issues like paying taxes due to the reduction of the effective corporate tax rate and obtaining construction permits, it has already become easier. But Japan is still ranked low in areas when starting a business. According to a survey run among foreign companies, the main reason for investing and doing business in Japan is the size of the market, but it's the most attractive factor. Size relates to the high number of population and strong buying power comparing with other Asian countries. And next appealing factor are infrastructure and the market as a proving ground for measuring competitiveness of new products and services. On the other hand, the top negative factor is the cost of doing business in Japan. It's followed by difficulties securing personnel, such as engineers and persons with language skills. So now let's take a look at some examples on how the Japanese government has been working on improving the business environment. And regarding the problems with securing personnel, the Japanese government has come out with several initiatives and policy changes. One of them is a green card for highly skilled personnel. The permanent resident status can now be obtained much easier and faster, depending on the applicant's skills. It can now take only 1 year instead of 5. As you can see, the initiative has been a great success and the number of approvals has been gradually increasing. Apart from encouraging highly skilled personnel, Japan introduced also a new residency status for skilled workers. So industries that are having difficulties in securing domestic human resources can now hire foreign nationals who possess certain specialized knowledge or skills. In addition, foreigners are able to start working immediately after arrival to Japan. Another shift in immigration policy is so-called startup visa, which is a great improvement on starting a business in Japan. And it's a system that grants a temporary conditional residence permit for entrepreneurs who want to build a company in Japan, but they don't have enough money or time to apply for the business manager visa. Unlike the business manager visa, which is difficult to obtain and can be a deal breaker for many entrepreneurs, with the startup visa program, you only need to prove that you launch an innovative business. And at the time of application, an office isn't required to establish resident status, and nor do you have to secure capital or hire staff at this point. And Japanese government has also come out with several measures which aim at enhancing innovation, such as 25% income tax deduction for corporations, organizations, and CVCs that for the purpose of conducting open innovation invest in startups. Or establishing a new tax system that promotes 5G related expenditures. And in general, startups are seen as a driver of innovation in Japan. So improving business environment is much directed to help to create and grow startups. To strengthen the domestic startup ecosystem over the next 3 years, the government is focusing on enhancing the ecosystem in the 8 cities around Japan. You can see them on the map. The plan consists of several strategies, such as public procurement for startups, cutting-edge acceleration programs, or gap funding for tech startups. To make the environment even more convenient for innovative challenge, a regulatory sandbox system has also been established. It allows the companies to truly start and try out new business projects with new technologies or services. On the basis of the data acquired from the projects, the Japanese government aims to introduce adequate laws and regulations. It's also important to mention that the recent pandemic has brought new opportunities and changes to the Japanese market. JETRO has actually introduced some of them in video series with and beyond COVID. You can find it on our website, so if you'd like to know more, I encourage you to check it out. But I'd like to give you just a few examples, which are quite groundbreaking for Japanese working environment, like growing telework trend or increasing cashless payment, and bringing the digitalization of administrative procedures forward. So we've come to the final section of the presentation, which is some information on how JETRO supports foreign and many among that Estonian companies that want to expand their business to Japan. The main focus of JETRO activities is supporting investment to Japan. Our priority target are businesses that contribute to innovation in Japan or to revitalization of local economies. So ICT, life science, AI, fintech, or renewable energy related companies. In 2019, we led 95 of such investment projects to success. We can support business related to Japan at any stage, starting with market information and supporting in establishing a base in Japan, helping out with obtaining visa, etc. We have temporary offices spaces called IBSC in major Japanese cities. You can use them free of charge for 50 business days. We can also introduce government-related agencies, tax or legal experts, as well as connect foreign companies with local governments and potential business partners. Of course, last year we had to adjust our services and have been providing various support, mainly online. So to support what I've said, I'd also like to show you what Polish office has been doing recently. So before the pandemic, in autumn 2019, we've organized a digital innovation mission to Japan. 10 companies from Poland, Czech Republic, Hungary, and Lithuania traveled to Japan and took part in dedicated B2B meetings and seminars, as well as visited CTEC, one of the most prominent ICT trade shows in Japan. Unfortunately, no Estonian companies applied at that time, but I'm looking forward to your participation in our next missions. Since last year, we've been active mainly online. We organized business matching events, trade shows, and webinars for different industry sectors. Only this year, thanks to different online events, We had already supported medical, ICT, biotech, and food sector companies in finding potential business partners in Japan. Also, just last month, we finalized the application process for contests for foreign startups that are interested in Japanese collaboration. And you'll be probably happy to hear that among winners, there are 2 companies from Estonia, which will be able to virtually exhibit at the incoming CTEC Online. And speaking of incoming events and initiatives, there's actually a lot of going on in incoming months. Some of these events could become a gateway to expanding your business to Japan, so please check them out. Each one is dedicated to a different sector, so I hope you find something of your interest. And of course, it's just a small part of what we do. You can find more details on our website. And Mr. Yoshito, as he already mentioned, he's our dedicated project manager for Estonia, so please reach out to him if you'd like to know more. I also would like to mention that we have a very helpful website with a lot of useful information on expanding your business to Japan. We also publish various reports and information, and they are available on our website in several language versions, although I'm sorry to say that I think we don't have an Estonian version. So, but please check them out. And if you're interested in Japanese market or Japanese business, please remember to talk to JETRO first. We will warmly support you and make efforts for your success. And if you have any questions regarding our service and today's presentations, you can contact us via this email. The above one is for the Warsaw office, and the second one is from Mr. Yoshito, who, as I mentioned, is our representative in Estonia. So that will be all. Thank you for your attention.
Thank you, Nina-san. It was a really informative presentation, and it was really interesting that also the JETRO also promote some activity together with the Japanese companies. So as you saw some of that, for example, upcoming event, if you are interested in, please contact us. Okay. Now, do you have any questions about the JETRO service or JETRO's organization? Okay. And then for the Zoom participants, do you have any question? If you have, then please write in the Q&A box or this chat box. Okay, so seems like there's no question at the moment. But as I know that the Japanese people and the Estonian people something in common that we don't ask questions right away. Maybe later, if there's a question, just let us know, and then we will reply to you. Okay. Okay. Thank you, Nina-san.
Yes, thank you for inviting me.
Okay. And now we will move to the next speaker. Now Mr. Yuri Shibahara is just behind the door. So let's have a just 5-minute break, and then we will set up the presentation, and then we can start. So for that. Okay. So let's have a 5 minutes break, then come back 5 minutes. Okay.
I should also exercise my own judgment and edit the video before distribution for the omission of any footage in association with the confidential information, trade secrets, reputation risk of any entity and person. As the audience, you should only use knowledge you gain from this seminar as a general guidance for your legal strategy planning, not as a concrete legal advisory suitable for each and every different company with different interests and objectives. Hence this disclaimer to help you know. The information provided during the seminar is based on the legal interpretations of the status quo and offered as a generalized guidance from my own experience, not as a legal advisory for any specific legal inquiry. The audience must seek necessary legal and accounting advisory from the competent professionals and authorities for their individual specific matters at all times. Neither of I, as a private person, TSTLU, or Enterprise Estonia, shall be responsible for any direct or indirect loss and or damage caused in relation to the information distributed through this seminar on or the interpretation thereof. So that was it. Now, first question from you that I shall cover is this: how to understand the Japanese mentality, status and hierarchy in formal and informal environments. I will try my best to give you as much clues as possible during this seminar. Generally speaking, there are 3 key points. First, people with more years of living or experience are automatically better rewarded in the society, regardless of their actual skills and achievements. Just because someone has breathed in and out the air for longer than you have, you need to use different verbs and nouns when you talk to them. For example, Japanese school starts in April, and I was born on the 18th of April. I have 11 months of friends who are in my same academic year who would talk to me in the normal, friendly way. But for whoever born 90 days before me, who were in the 1 academic year before me, I need to talk to them in the polite form and also the I'm lowering myself down form. So the verbs and noun change whenever I have to talk to someone who were born 90 days earlier than me. So that's how it is, and that doesn't change still now. The second key is men over women. This is sad, but I will touch on this topic later in the seminar. And lastly, customers are God. From a European zero tolerance standpoint, Japanese staff may look quite submissive in front of the customer. That is what is expected in Japanese customer service. But these social values or irrational evaluations are not much applied to non-Japanese people. So you don't have to worry about these so much. Well, when you are a young Japanese woman with lots of knowledges and ideas, and somehow have gained the ability to explain them in another language, then in my opinion, life in Japan was suffocating. That is why I shaped my life to mainly work for non-Japanese clients, and I avoided typical traditional Japanese work environment. I've been serving startup clients, including Estonian ones, for more than 5 years. And I myself now also develop my own startup company here in Estonia. So I do understand, especially common to see in Estonian companies, that startups tend to forgo legal due diligence, just launch their products or services as soon as the prototype proves to be working, experiment and grow along with the users, and correct any mistakes if some users or authorities object. But this kind of trial and error mentality doesn't go well with the Japanese customers. They take for granted that any business conduct must be offered with perfection. We're taking baby steps, it's a beta version, hence it's free. This kind of excuse doesn't work in Japan. For example, app providers tend to just avail the app with lots of functional bugs. The onboarding process is minimal because startups believe that people would just start experimenting, and the intuitive UI design must naturally navigate their journey of user experience. However, this approach is not favored by the Japanese because they require full explanation from the very beginning. They are opposite from being experimental. If they don't get convinced in a lack of sufficient level of explanation about service, they don't get the courage to sign up. And even when you manage to gain the trust to be a free early stage user of the app, if they notice that the app has some bugs, then they feel as if they were fooled, complain anonymously in a very aggressive manner, or just delete the app and never come back. You may have had the image of Japanese people being super polite and kind, but you can't expect them to behave like Europeans or American users. App providers tend to let both of themselves and the users figure out the usability together, and expect the users to be patient with the bugs and cooperate to improve the app in exchange of free usage of the beta version of the app. That's usually how it works in Europe and the United States, but not suitable for Japanese users. Because the customers are treated like God in Japan, even the free users expect high standards. For the Japanese potential users to turn their small interest into an action, you need to satisfy their expectations towards protection through a great amount of explanations. The same goes for business collaboration. This is why they demand for many meetings to receive an excessive amount of explanations before they move on to an actual action plan. If you pursue business with a Japanese partner, you should allocate at least 3 months until you reach the contract signing stage. If you must draft a new bilingual contract, you need an additional 1 or 2 months, I would say. And once they're engaged, of course, they expect perfection. They feel most comfortable when there are rules to follow, so that the same perfection would be observed by everyone. Breaking the rules is a huge no-no. This is why it is very important that you make sure everything works without any problems before the launch in Japan, and lawful conduct is the most lethal when forgone. So what happens when a company is revealed to have been in misconduct? Before the police or sorry, my shirt is not good. Okay. Before the police or regulating authority starts investigation, perhaps some users already start questioning. Companies had better have their SEO or content specialists to take a regular online reputation research in the local language so that they can pick up the issue before it gets to the attention of the public. In terms of legal consequence, Japan is not like in the United States. Japanese customers won't submit a lawsuit right away, and the Japanese legal system also doesn't recognize the concept of punitive damage. The good news here is that companies in Japan will only be responsible for the damage and loss to the extent of actual and foreseeable costs. However, I urge you to think about the reputation risk. With Japanese mentality, people remain silent until someone with an authority points at the target with a big voice. But once they find the target to blame, it becomes unstoppable. For example, Japanese police filed a case against Uber Eats for violating the border control act recently. They didn't thoroughly check the identity of the delivery partners, even after 3 times of warnings from the police, allowing foreigners without valid work permits to have been regularly working as Uber Eats delivery partners. As a consequence, the company itself, its Japanese CEO and the CCO, Chief Compliance Officer, have been referred to the prosecutors, and they're now waiting for the decision whether to be prosecuted or not. It is important to understand that none of them have yet to be prosecuted, but their full names have been reported on the news, so their career will be quite much doomed in Japan. Japanese companies don't hire someone with a criminal case record. In terms of public relations, as soon as this news came out to the public attention, Japanese people started accusing Uber Eats online on another level. It's not only coming from the actual customers who may have had some bad experience with Uber Eats. Bullying culture of Japan, bullying culture of Japanese people has brought down the corporate reputation even worse. Now, Uber Eats in Japan is tainted with a series of negative images and false allegations, such as they favored illegal immigrants, they exploit people on low wage, like the slave trade back in the time. The delivery partners are not hygienic, so you shouldn't eat anything from Uber Eats, etc. Now, the non-Japanese delivery partners often struggle with police reports, as some extreme Japanese people call the police on false allegations, such as an illegal immigrant is waiting in front of the restaurant as an Uber Eats courier, please come and arrest. Not only Uber Eats lost potential customers due to their damaged reputation from their negligent conduct, but the problem is that now it's growing to be hate speech against foreigners and low-income manual workers nationwide. There is no question that Uber Eats in Japan will struggle for the next few years with sales, hiring, and daily operations. Now you can see how one legal misconduct can bring down the company with a snowball effect. But what could have been done better when the unlawful practice was publicly accused? So saying sorry should not be avoided. Uber Eats should have said sorry right away. Again, unlike in other countries, saying sorry in Japan doesn't make you assume a legal responsibility by itself. For example, I was physically attacked by a guy who obsessively pursued me while I was working in the law firm back in Tokyo, which left me lifelong damage on my left ear. As soon as I filed a criminal case for an assault, he confessed in the police station and said, sorry, I didn't intend to harm her. It was just an accident. Again, sorry, it was an accident. Before the incident, he had been telling me, I'm the only one who can understand you in the whole world, and you're the only one who can understand me the same. He once grabbed my arm on the street and tried to pull me into a taxi, saying, I'm going to take you home, meaning that he was dragging me to his house, not mine. He also said, I wish you were disabled somewhere on your body, so other guys wouldn't love you, and I will be the only one who would take care of you for the rest of your life. I thought it was enough to recognize his motive for causing a permanent physical damage on my left ear. Certainly, he was referred to the prosecutors, but after all, he was not charged on his criminal case because he committed to this alleged assault in a place where no CCTV or witnesses were present. Both of my and his accounts of the incident and him saying sorry repetitively didn't constitute enough grounds for criminal case because he didn't constitute enough grounds for prosecution in the absence of other witnesses. This is one of the reasons why I left Japan. This guy still walks free while I'm making every effort of hiding my whereabouts. I couldn't feel safe to live there anymore. So from my own horrible experience as well, I can tell you that saying sorry doesn't have the legal effect as you would fear in your legal culture. It doesn't cost anything to your company for saying sorry in Japan once the misconduct came under the light. Rather, it only works to your favor when pronounced effectively. So you should not be afraid of saying sorry in Japan. Let's look at how other international companies failed to minimize the backlash because they were afraid of saying sorry. Uber Eats failed to say sorry, only referred to the same non-apologetic written statement whenever journalists questioned, and fueled the backlash. It looked like the legal counsel from the headquarters advised what to do and what not to do, because clearly avoid saying sorry and providing no further comments is the typical tactic non-Japanese lawyers would advise. The Japanese CEO even stated during the police investigation that she was not aware of the unlawful conduct as the information had not been directly escalated to her. Whether her account of the story was true or not doesn't really matter here. Japanese people dislike this sort of statement because they only see it as if she was making an excuse to get away from any responsibilities. They hate it, especially when it comes from a Japanese person, and it's even worse if it is a highly educated woman. I guess she was only allowed to explain in this way by the in-house counsel. But if she could otherwise state in the Japanese way, like, sorry, I was not aware of this because blah, 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 but I feel terribly sorry that we intentionally ended up allowing illegal workers to function as our delivery partners, then it could have been much better. I know this already sounds risky from our legal culture, meaning European or American or British legal culture, but in Japan, this only means she feels sorry, doesn't mean that she assumes the responsibility for the corporate misconduct. Another well-known example is McDonald's Japan. They imported chicken nuggets from China until 2014, when it was reported that the nuggets were made from chicken past the expiry date. The CEO of that time was a Canadian, and she announced at the press conference that McDonald's had been deceived by one of its suppliers from China and projected McDonald's on the same side with its customers as the victim from this misconduct by the Chinese supplier. When I hear it in English, I find her a very smart person who is capable of turning the scandal into a moment to gain rapport with the angry customers. I can totally understand from the North American legal culture why she didn't use the word sorry at all during the press conference. But Japanese people took it very negatively. Japanese media and people recognize her as a cocky woman. By the way, it has been on news headlines with this particular Japanese phrase, takabisha na onna, if you know the Japanese word. This phrase never gets used on men, it's only for women. So they characterize her as a cocky woman who cannot understand people's minds. All they wanted to hear was a sincere and repetitive pronunciation of sorry. And if she did it in Japanese only for this one phrase, I think she could have won the report she tried to gain. So here is what I wanted you to know before launching your products or services in Japan. Launch with perfection, give as much explanation as possible. If you made a mistake, say sorry right away. Now, let's talk about the economical ways of achieving compliance to the Japanese laws and rules from the relevant authorities in your business field. First, I urge you not to waste your time in trying to understand from what the translated version of the Japanese laws say. The quality of the translation is not so great. So even if you tried, it's difficult to understand from the translated version. And even in Japanese, understanding Japanese laws is like mastering another language. That is why there are legal professionals, and getting certified as a lawyer takes a lot longer compared from European standards. Full translation ends up too complex and difficult to comprehend. Because there is a translation rule, when the sentence is in one sentence, even though it is very, very long, as a translator, you shouldn't break it up. So one sentence translated into one sentence. However, in Japanese laws, usually laws and contracts in Japan are written in a very, very long, complex sentence. And if you try to translate it in the righteous way, it's actually more difficult to read in English. That is why I'm saying that it's not the best idea to jump onto the full translation of the Japanese laws. And because the laws themselves are not helpful from the practical standpoints, the relevant authorities provide guidance materials in Japanese. Procedural matters are not specified in the law. For licensing, ministerial ordinances are more important. Some matters are not even codified, but demanded on a request basis. For example, when a company wants to import food from Europe to Japan, because it's a food, there is a quarantine and laboratory testing. But from the law, it doesn't say that on the first time of import, if the food is already laboratory tested in the exporting country, then the law says that on the first import in Japan, the quarantine office doesn't have to require another test for the quality check. However, when you actually start doing the import business, you will be notified from the customs clearance office that you need to actually take this test. And if you say that, but the law doesn't say it, still the customs clearance office say that we ask for it on a request basis. And if you don't comply with this request, then it's going to be really delayed, or maybe it's not going to be approved. So you eventually just end up doing the test again. So that's what I'm talking about as request basis. And guidance materials from the relevant authorities cover this information. So to get around this language barrier, because the guidance materials are in Japanese, you need someone bilingual on your side. If you're exporting goods to Japan, you can simply rely on the Japanese distributor. If you're a service operator and need licensing in Japan, definitely hire a local person on the ground. In Japan, it is still almost impossible to complete administrative registrations without the Japanese telephone number, which was landline before, but nowadays allowed to be mobile phone number, valid address in Japan, and someone to file application forms in paper with a company stamp. It is mostly the case still now. As you heard from the JETRO officer from the Warsaw office, I presume, if you meet the criteria, you can also get the free consultation from the bilingual JETRO officers and become eligible for getting an office space in JETRO's shared office space in Japan. So that's also a good consideration point. But when you start offering something totally new, which are not covered in the Japanese laws yet, then you will need to seek advices from the relevant authorities, as well as a legal professional who are competent to interpret the Japanese laws and ministerial ordinances. Bilingual service will double or triple up the bill. So my first recommendation is, if you have a bilingual talent, ask in Japanese. And then obviously this will reduce the legal cost. The second thing is, if your inquiry sounds vague and broad, law firms find the best opportunity to offer an extensive advisory, and you will regret it when you see the bill. So list up what you already understood quite well. And if you, as you must already took some initial research by yourself, you should cite the reference materials that you already read and limit the question range. This will also reduce the research hours at the law firm, and they also shouldn't have to write up a lot of guidance materials. So it will reduce the billable hours from the law firm. And it is also important that you clearly define what you want to achieve, how. If your business model is not well understood, the advisory you receive may not be spot on. And if you clarify further on the second round, both of you and the law firm lose the time and the bill will increase. Provide as much product or service information as possible from the very beginning. And if there can be some alternative options, such as technical alternative options, then please list them out as well. I wanted to show you how law firms count the billable hours. This is my billing sheet from 2014 without client names and the indicative project names. we only build hours that are reasonable. We only build hours that are reasonable to be charged on clients, but this client could have lowered the bill if they made a little bit more efforts for efficiency on their side. You see that there are 2 calls from clients. They were often reluctant on providing all necessary information in one go over an email. There was some missing information, so I had to message them to ask for it. So that was the drafted email to the client. And then they telephoned on the next day for a quick update. It was quick, but in the unit of 0.1 hour, I had to charge for it. In the same time, for this 6 minutes, we can read quite a lot on emails. To prevent he said, she said troubles, we prefer recorded communication. Hence, email is the best way of communication for us. Successful law firms are very busy, so we prefer receiving all necessary information at once, not by pieces. If the client fails to cooperate with us, we feel justified to charge another 6 minutes for sending out 2 or 3 lines of reminder email and another 6 minutes for receiving a phone call or email from the client. When the client keeps doing these on a daily basis, in a month's time, they will gain additional 4 hours of my attention, which increases the bill by 600 euros. So when you seek advisory from a law firm, write about your situation and answer to the questions from the law firm very clearly, and try to reduce the hours of overall communication.
Yes. You have a question?
Yes.
Yes, I want to know that how direct is do I have to be defining my goal when going to the lawyers?
Okay, so if you have...
Can I be as direct and honest if the goal is like to avoid some taxes or something like that?
Of course, you can be direct, but the answer you will get wouldn't be like, oh, you can do it this way, so you can just, go into the gray zone and do it with illegal things, but you wouldn't be caught. The answer wouldn't be like that. Usually the answer from the very competent, smart lawyers or the paralegals would be like this. Well, there are some companies who also pursue that, and I can tell you how they get around the law.
Mm-hmm.
If you are interested, I can tell you about this.
The goal is just to do something, and I want the lawyers to help me to do this legal way, not in the gray way.
So in the legal way, you can also get the answers, but a lot of times Japanese laws are not up to date in a fast pace. So if you start doing something completely new, then the laws are not up to date, and the laws cannot really define if it's legal or not. So the answer from the law firm would usually be on like, you could possibly do this, but there are risks like this, and to minimize these risks, you should better do these, something like that. But yes, I recommend you to be very direct. If you have the certain objectives or goal, you can be direct. But if you have some alternative or backup plans, like I want to do this, but if this is difficult to be achieved, then I can lower it down to like this level. If you have the options, then also provide the options at once at the beginning. Yes. Any other questions? Okay, then I shall continue. So as you heard me, I was a bilingual paralegal. When I was 19, I specifically chose not to be a lawyer in Japan. I'm just counting my age because I was born in April, and as soon as the school year starts, I'm already in the next year. So usually for people who were born in September, October, December, January, February, March, they just start the high school at the age of 15. But in my case, when the high school started, I just became 16 right away. So that's how it is. So let's compare it. When I was at the high school, I went to the school with the university attached to it. So I didn't have to take the entrance exam for getting into the university. But normally for people, high school time is devoted for studying for the uni admission exam day and night, during which time I could focus on learning English on my own. And by the time I graduated from the high school, I was participating in English speech contest twice. And both times it was on the impromptu speech contest. So there was a title given and you don't have any time to prepare for anything. You just go to the stage and talk about the topic. This kind of speech contest was full of returnee students who were either raised in another country for many years or who went to the international school in Japan. So they've been educated in English speaking environment. The contest was full of these people. However, I could still win as a champion twice in the speech contest. So during the 3 years of high school study and my own private learning of English, I could achieve a certain level of English proficiency. However, if I went to the normal school and if I tried to get into the university by studying for it, then I didn't have the time for it. And when you go to the university, if you pursue to become a Japanese lawyer, then there is no option for studying law abroad. However, because I chose not to become the lawyer, even though I took the bachelor in law and politics, I could take 9 months of study at Queen Mary University of London, where I could also study the law from the common law perspective, which really led me to the career path to become the paralegal. And when you graduate from the university, when you want to become a lawyer, then you will have to enroll yourself in the LLM program. So that is another 2 or 3 years of not much time for fun. Whereas I could just start working at Moore Hennessy Lewis Group, and then I moved to the international law firm because they kind of headhunted me. So there was no gap between the first job and the second job. And basically, to become a Japanese lawyer in Japan, there is not much time to study English extensively. And even in Japan, university graduates in my generation underwent 10 years of English language education. Most of them also received some years of speaking practice at private language school or tutoring, but still they can't achieve business level proficiency of English. And then let's go through the timeline. So at the age of 26, if I were to become a lawyer, then I needed to get the bar exam in May and then take the summer clerk job. And then the result of the bar exam comes in December. So you're kind of losing 1 year already just for waiting for the results. Whereas I, as a bilingual paralegal, could just start earning noticeably more than a Japanese associate lawyer by this time. So that is why I chose to become the paralegal without any licenses. And at the age of 27, finally, when you get the bar exam result, then the legal training starts. And this is for 12 months. And then you also need to get a job at the law firm or at the prosecutor's office or at the court. So again, 1 year is passed. And at the age of 28, finally, the lawyers can start working at the law firm and get paid for about 44K annually. In my case, at the age of 28, that was when I went independent and started serving international clients. Because I was independent, I could choose my clients, which also gave me a lot of flexibilities. And when you are successful at working as a lawyer in a law firm, then around the age of 33, they get sponsored by the law firm to study abroad. And if they wanted to get the dual license, then it takes 2 years of study and training and taking the bar exam elsewhere. Whereas I took the sabbatical year, and I was actually on the round the world trip journey. And on the middle of this journey, I was in Estonia, and then COVID-19 hit the world. So I was happily stuck in Estonia. That's why I'm here. And then, so the lawyers passed after 2 years of studying and training abroad. They finally become dual licensed lawyer. And if you get this dual license, then the wage will be really high, around 100K euro annually. And in my case, I didn't choose to become the lawyer. I wouldn't get 100K euros per year, but I made my own startup company, and I also applied for my residence permit in Estonia, thanks to YOLO Group who helped me out. So I am like more than innocent, right? So that was me. And what I wanted to say is like, so you can see why Japanese lawyers can't achieve a high English proficiency level. However, when you meet some Japanese bilinguals, you also shouldn't really expect them to be native level proficient in English, because it is really difficult to find someone who is confident to do the legal reading and writing in English and in Japanese as well. In both languages, it's a very difficult pair. The duration of living abroad cannot be used as a signifier to determine one's bilingual proficiency. For example, I was in London for 9 months, that was it. And at the end of the 9 months, I also got certified as an English teacher from CELTA certificate. So the duration doesn't matter. But there are so many Japanese people who proclaim to be bilingual after living more than 5 years in English-speaking environment, still keep speaking with wrong grammars and pronunciations, like pidgin English, cannot manage business communication, but blame on the mistake on lost in translation phenomenon, because other people can't fully understand English, so their failures wouldn't be found. And I wouldn't say that they are lazy. I would say learning another language just exceeds the brain capacity of Japanese people, because our brain is already almost fully occupied by mastering our own language. Japanese language is too different from other Indo-European languages. And we have 3 different kinds of letters. 2 of them are just the phonetic letters, like alphabets. But the third and most complicated one, kanji, has an extensive entry with each changing its pronunciation depending on the context. Altogether, middle-class graduates must have had the literacy of approximately 2,000 letters in total. Plus, there are 3 different versions of the Japanese language, as I told you about, this hierarchy thing. So we use different verbs and nouns depending on the hierarchical relationship. When we think about other versions of this language, which differentiate for being friends, female or male, or speaking rough, plus regional versions, etc., I'd say we have already used up about 5 different European language worth of our brain capacity, just to achieve a minimum required level of Japanese for understanding news context. So only a few Japanese people managed to achieve native level proficiency in both languages. It doesn't matter how long they were exposed in English-speaking culture. I have a handful of friends who have not even lived abroad nor studied in international schools, but able to read and write beautifully in business context English, speak far better than the typical problematic bilinguals. These exceptional people are usually able to communicate in more than 2 languages, not just English and Japanese. So bilingual proficiency in legal research, as I said, this is really difficult to find. Japan is not a common law jurisdiction, and the contract culture is quite different from what we know in most countries of Europe, UK, and the United States. You shouldn't expect Japanese local lawyers to fully understand the Japanese translated version of an English contract. There are so many legal concepts which do not exist in Japan. so as the approach for dispute resolution. I will talk about these in the part 2 of our seminar. And including me, whoever completed a legal study course in a foreign country in English is very likely to have the competence to work on bilingual legal context. So this one, 外国法事務弁護士, attorney at foreign law. You may encounter this particular profession during your legal talent search in Japan. The fee is usually on the highest range in Japan. These lawyers are admitted for practice in a foreign jurisdiction, but not in Japan alone by themselves. They can serve clients on matters concerning their own jurisdiction while in Japan, and with the cooperation and supervision of a lawyer admitted in Japan through the bar exam of Japan, then they can also serve for clients on Japanese legal matters, but the same goes for non-licensed legal professionals such as paralegals. For a lawyer from a non-Japanese jurisdiction to gain this title in Japan, there is no requirement for the Japanese language proficiency. So they usually work along with a Japanese lawyer who are only admitted in Japan to serve on Japanese legal matters in English. Sorry, I'll say it again. So these 外国法人弁護士, attorney at foreign law, would usually work along with a Japanese lawyer who are only admitted in Japan to serve on Japanese legal matters, but the attorney at foreign law would just give the service in English, and they both actually heavily rely on highly bilingual paralegals for that. So here is a list of possible talents you can seek. The first one is very normal. The bill will be very high. But as an insider, I need to tell you this truth. In most cases, they still heavily rely on bilingual paralegals. And the second one, those who studied law outside of Japan don't usually choose to get licensed in Japan. You can find them amongst the bilingual paralegals and in-house legal officers. Whether licensed outside Japan or not, they usually can do most of what you need. Success as a lawyer depends on what level of paralegal he or she has. If they have one, they will bring the best paralegals to client meetings, so you will have the chance to meet. Usually, this type of highly skilled paralegals are bound by non-solicitation obligations by the firm, just like lawyers. But when it's restricted just the same way as lawyers are, it is very likely that the restriction is on stealing the clients from the firm, not becoming an employee of the client. So there is a good chance that you can steal the best paralegal from the firm in this loophole. When they work in a law firm, they always have to serve the firm's clients under the guidance and supervision of a Japanese lawyer due to the restrictions by the Lawyers Act. Even though the partner lawyers fully trusted my ability and started to forego their obligations to supervise, I had to force them to check what I prepared on their behalf. This legal constraint will disappear when you hire one as your employee, because your company will no longer be a client, and the unlicensed capable person can just represent the company as an employee. It may be difficult to find and hire an in-house legal officer from another company, especially when the person was sponsored by that company to study law abroad. Usually, companies lock in these personnel for 5 years after the sponsored study. If they quit the job, they have to pay back the tuition fee to the company. But still, you might be able to find someone who was already fed up with the Japanese sexist and hierarchical business culture. If you meet the one that you want to steal, but feel constraints due to the relationship with the firm or the company, then you can probably follow what my past client did. We need someone just like you, truly just like you. If you say it, they will get your message. And if you hire someone young, by young I mean before the age of 40, please come up with a sound job title, such as lead something or something manager, because Japanese business culture still under-evaluates the young and female. Having an authoritative title is the good way to get around. The last one, Gyosei Shoshi, Certified Administrative Legal Specialist. This one can be found online with this Japanese professional title. Again, because of the legal constraints from the Lawyers Act, this certified specialist also can't give legal advisory for specific inquiry. They're a good alternative from a lawyer when you are already sure about legality and if you only need someone to draft a set of bilingual contracts. And question number 2, Japanese way of contract management. How do Japanese companies deal with variation orders and changes to the contracts? Contract management differs by companies. From what I observed, some companies had a specific officer for contract filing and upkeeping inside the legal department. All contracts come to one person. This person scans the paper contracts and sort them in the folders, both physically and digitally. Registered contract dates in the spreadsheet, so they will not miss extension or renewal of the contract. That was a very organized, good practice. But most Japanese companies didn't achieve this type of organized contract management because Japanese people value on meetings, and that is how they gain trust from their clients. The sales representatives, which is called eigyo in Japanese, they are given broader responsibilities, one of which is to keep the contracts with their list of clients. Legal department doesn't even know when the contracts expire or have to be renewed. It simply depends on the sales representative. To remember when the contracts expire, and I have seen cases where they forgot. And the next question, yes, this second one, how do Japanese companies deal with variation orders and changes to the contracts? Let me cover this topic as I talk about these. So here is how you can execute legal documents with your Japanese counterparts faster while lowering the legal costs. First, get the gist of it. Please don't have everything translated. For example, the first legal agreement you are most likely to execute is the non-disclosure agreement. Without this in place, you are risking trade secret leakage. As I explained, I'm not a licensed lawyer, so I can't provide a legal document or advice for a specific inquiry for a fee, but I can still legally offer to share what I use as your fellow business owner. So I'm going to share the NDA checklist from my Estonian startup, TestOU, which can be sent from Mr. Yoshito over the email. And I want to show, if I may. Okay, so we're going to have a break. Okay, so I'm going to finish this slide. And when you attempt to understand the contract contents from the translated version, I recommend you to get summary translation. Law firms can do this with confidence, but if you're asking a highly skilled translator outside of a law firm to translate, then you need to understand which article must be translated. Unless the translator has a legal background, he or she can't determine which element can be omitted from legal translation or not. So now I'm going to answer to your question. When you understand the contents and wish to modify, your counterpart's legal department may hesitate to accept contract modifications, or the sales representative person already knows that it will be such a hassle to involve the legal department. Many of Japanese companies operate with a small team of legal departments. Some companies operate without one and just hire a lawyer on a project basis. Or perhaps none of the lawyers understand English contractual concepts. So for this instance, they're not flexible with contract modifications. But because the sales representative person have bigger responsibilities and discretions than what we expect in them in our business culture in Europe, maybe they can agree to go around the rules to start the project with you sooner without much involvement of their lawyer. So changing the agreement wording through a memorandum of understanding is usually easier for them to accommodate.
I have incorporated subsidiaries in 30+ countries, many of them in Asia. I usually use a good accounting company for incorporation, etc. They tend to be more down to earth and cheaper while providing the same or even better quality work. Would this also work in Japan?
Okay, I can answer on this. So the law firm that I was working for back in Japan was also partnership with the very big international accounting firm. I wouldn't name it, but it's very international and you would know it. And the thing is, yes, the accounting company could really help incorporating the company and doing some, payroll stuff, organize. And even sometimes if you ask some legal questions to the accounting company officer, they may give you the answer. But usually they have the lawyers on the background. In our case, it was the law firm that I was working for. So they have a good communication between the accounting firm and the law firm. And that's how you can possibly get a cheaper legal advisory through the accounting firm. But when it becomes more complicated, then surely the accounting firm will redirect you to the law firm that they kind of have the good relationship with. Yeah. And Fred said, so this is the agenda for the part 2, and I will try to finish it in about 45 minutes, so you can have some time to question some, matters. So first, please don't lose money and time in contract translation. As I said, summary version reads better than full translation. And if you really want to, you can make a full translated version when the document is finalized. And it's also important that you know the fee range. With a law firm, as far as I am aware of, the fee per word, per English word, would be somewhere around 60 Japanese yen. And if the translation is from the Japanese version into the English version, then it's 55 Japanese yen per Japanese character. But with a competent translator, for example, my fee per word is 30 Japanese yen, and per character from Japanese to English is 27 yen. So there is a kind of, difference by double. And these are not translation mistakes. So if you see something like this, and if you want to question if the translation was done correctly, don't question. The thing is, there are vague phrases in the Japanese contracts, and you will see it very commonly. For example, when the problem is found, it says parties shall consult with each other in good faith. And how to resolve it? It also says, in the event of dispute, both parties shall consult in good faith and reach an amicable resolution. However, from our side of the legal culture, let's say European or American or British, when the problem is found, it's kind of already too late to talk to each other in good faith to bring out an amicable resolution. That's why there is a contract, and that's why there is a kind of penalty. That's why there is a kind of conditions on how to finish the contract without waiting for the contract ends. However, in Japan, because somehow Japanese people believe that everyone want to be good people, and they don't really want to argue with each other. Even the contracts say that they would consult with each other in good faith. Yeah, but it's not a translation mistake. It's actually what it's written in Japanese, and it's been translated in the faithful way. So I made a list of things that you can refer to when you engage a translator or a law firm. First, when you translate from Japanese to English, if you have a strong preference over the British spelling or United States, American spelling, you can just say it. And when you see the contract in Japanese, the parties are referred to as ko and otsu. It's like party 1 and party 2. They don't name it like Enterprise Estonia and Tasty. So if you want the translated English version to refer to the name of the companies, because it's easier for you to understand rather than seeing party 1, party 2 all the time, then you can just specify in what way you want to see the names of the parties. For example, refer them with company names or refer them with position. You can just specify to the translator or the law firm, and they are gonna accommodate your needs. And when you translate from English to Japanese, there are so many factors to be considered because there are so many things which do not exist in the Japanese contract culture. Well, this is involving a lot of Japanese language, so I'll just give you the list so you can send it to the Japanese translator. But when the translator needs to translate, they will have to ask which one to go. And if you could give them the direction, that's better. Without the direction, they will be in a kind of dilemma, like, should I go with this mas or should I go with dearu to suru? And when the contract is very long, usually there will be more than one translator to work on the same contract. So if you don't give them the clear guidance, then they might have to just toggle them up later on together and change all the word endings and change all the writing way of mata wa oyobi no tame, these kind of things. It's going to take their time and it's going to delay the delivery time. So if you have some preference, you should have the preference and just give it to them. And the funny thing is, in English contract, we see and or, and/or, and we do understand this concept. But in Japan, we don't have this concept at all. So some translators just literally translate it as and into oyobi and then or into matawa and give the slash. But when the Japanese lawyers who don't understand English contract culture see it, then they get really confused and they think that the translation was done in the wrong way. So I suggest just tell the translator to use one or the other based on the context. And if the person is really proficient in Japanese, they can figure out which one is more applicable in the Japanese context. And also the English contract says for the avoidance of doubt quite much, but this particular phrase also doesn't exist in Japan. And the translated version usually have this very complicated saying like, gigi o sakeru tame ni fugen suru to. This word fugen, we don't even use it in our life. I didn't see it until I saw this on the translated version of the legal contract. And this also kind of confuses the very Japanese lawyers when they have to read the translated Japanese version of the contract to review. So to remove this kind of complication, you can also ask the translator to choose one or the other from the bottom. Better way of translation by a real bilingual, you can just say, or just simply omit this whole for the avoidance of doubt thing, because without it, it still goes all right. And lastly, including but not limited to, this also doesn't exist in the Japanese contract. So this is really difficult to be understood when translated into Japanese. It says, 生年月日を含むがこれらに限定されない blah blah blah. It sounds like, you know, it sounds like it's looping back and forth again and again in Japanese. And the way to avoid this is to simply use either of との、などの or をはじめとする. These ways would just read much better and still keep the same context. So you can just give these lists to the translator and just seek how they can improve without making the translated version more difficult to be understood. Okay. So, sorry, it wasn't updated from the airport. I just made an update to give the question numbers, but it's okay, I'm gonna just carry on. So there was another question to seek how effectively conduct the meetings with the Japanese conglomerates. That was the question. And I would say it is often the case that the person you will be in frequent communication is a young bilingual, not the decision maker, because the decision maker is several layers high up there. The decision maker may see you on the initial meeting just for formality, but then disappears. You need to expect that decision-making process in Japan takes longer time, and Japanese companies also tend to demand weekly meetings, even when there is nothing important to talk about. Keeping in touch this way makes them feel reassured that we're working together, even when there is not much to actually work on together yet. This is why I estimate at least 3 months until a deal reaches an agreement. If you must create the contract in English from scratch and have them sign on it, then I would say allocate 2 more months. Because of the difference in language and contract culture, the legal department of the Japanese company may be hesitant to proceed with an English contract. Unless they are very competent and experienced in bilingual formats, then modify or seek an MOU. Have the English version as a reference translation and don't pursue hard to sign on the English version from your side. When you want to modify or vary the contract, then as I explained in the first part of the seminar, give them 2 options for modifying the contract. Directly modify the contract itself or make the modification through a memorandum of understanding in the appendix, because this way you will likely to get things done faster. And so next thing, please don't lose revenue by the Japanese taxation. I remember you, no, not you, but I remember there was Karel who said about the accounting firm. And if you have the advice from the accounting firm as soon as possible, that's better. But let me just give you some case studies from my own experience. Even when your company doesn't have an office in Japan, as long as your company has an employee or consultant on the ground in Japan to work for your company, to represent your company in general, such as being the local contact person to conclude contracts for your company and dealing with transactional matters with the local customers. This existence of person itself provokes the taxation complication, the concept of permanent existence, permanent establishment, permanent establishment. This is regardless of the fact he or she is located at the company's office in Japan or in his or her own house. This concern on the permanent establishment will matter when your company raises revenue in Japan. If the permanent establishment is recognized, revenues from the transactions arising from the Japanese customers is considered to be earned inside Japan, even if the receiving bank account is an offshore account. If the representative in Japan functions as a permanent establishment, your company will be subject to Japanese taxation policy, even if it doesn't have a legal entity or office in Japan. In such case, there will be a need for Japanese bank accounts to collect revenue and pay for the tax. It will make your accounting easier, actually, if you have the bank account in Japan. You can separately count the Japanese transactions in Japanese yen from the worldwide transactions, and you will pay for the tax in Japanese yen in Japan from the Japanese bank account. So that's the only thing you need to do if the permanent establishment is already recognized. But you'd better avoid it if you don't want to go into this. Another pitfall is when you have a Japanese company as a stockholder. I saw this about to happen with my client before. It didn't happen, we stopped, but it was about to happen. So when a Japanese company has the holding of more than 10% of your non-Japanese company's issued shares, then the anti-tax haven rules apply. If you want to offer the stocks for the investor or for the partner company, then just keep in mind that it shouldn't exceed 10% threshold of the already issued shares. And please also don't get deceived by the innocently childish grinning face of Japanese people. Another person questioned about the intermediary and consultant service. What should we know to trust them before we hire them? I would say there are lots of lost in translation phenomenon going on in Japan. So, for example, Japanese business persons, when they don't speak in English, when they just speak in Japanese and get the interpreter translate everything, they speak rather long, but usually don't mean much. Maybe you know that's because you speak in Japanese. For example, during the conference, Japanese business person would say, そうですね、それについてはですね、しかしながらですね、そのことなんですが、they just talk quite long and they just probably talk more than 1 minute. But for the interpreter like me, I can only say that they said we don't really have the answers. But they just can't say it out loud, so they just use a lot of free words like それについてはですね、ただいま検討しておりますが、and is really long. So you might just lose a lot of time through the meeting like this. And when they want to say no for what you ask for, they also tend to get away with a small laugh like this. Maybe you can ask them like, can you start launching this project in 3 months' time? And if they think that it's kind of impossible, no, but they don't say no right away, they'll be like, and you need to understand that this is not like, oh, I'm excited, it's great. It's not like that. It's more like, I can't say no right away because of the face culture, but I need to react to it. So I'm just giving a little bit of laugh. So yeah, you will also have a lot of lost in translation phenomenon in this context. And when the interpreters are involved, they're usually used as scapegoats. It's very unfortunate. I was in that position as well. It's really bitter. I don't like it. But when Japanese people don't want to show what they can't do or what they are not competent to do, and if they said something wrong or if they want to take back something that they said, if there was an interpreter, they would just blame on to the interpreter and say like, the interpreter probably didn't interpret in the right way, or the interpreter probably omit this information from how she was talking, blah, blah, blah. So actually also you will, when you get someone who can speak kind of okay in English, but not quite well, and some sneaky people just falsify or hide important information on the English version. This also happens. And when you notice that something weird was going on, they would just say like, sorry, maybe lost in translation. And this is why I would urge you to always have someone truly bilingual on your side to check before signing or before making a very important decision. So this intermediary consultant thing, be careful with intermediate level bilinguals who found the sweet spot just by being seemingly bilingual from their long years of just breathing the air in and out abroad, I would say, because you might encounter them and they would usually turn out to be a very exaggerated bilingual who just come to approach you. It's not like you ask for help, they just find you and come approaching you saying like, hey, I'm very experienced in bridging the gap between the Japanese companies and the non-Japanese companies. I can help your business. I work as a consultant and I will just make your business run in Japan with the commission. They talk big, but when they talk quite big, usually they can't do much. So be careful and find some clues. I would say that because you're approached by them in English and they proclaim to be experienced in consultancy, then you should also go in the English speaking way and ask for some reference interviews from their past clients. If they really had a good experience and good skills, then certainly the past clients would also recommend this consultant or the intermediary to you. So you will get the reference. And don't just ask for the reference in written paper, also get the contact information of the referee. So you can just telephone them or email them to get the real answer from the past clients. And for exports, it's really better if you approach a trading company. If you try to export and if you try to find the distributor in Japan by yourself, it will take time and you also need to assess them quite well. And the question is, do you have enough resources to assess? You certainly need someone who can totally understand in English and Japanese and totally also understand the nonverbal context. So that's why I suggest that if you are just exporting goods, then going with a trading company is the easiest way to go. Also, they take some commissions, but they wouldn't fake things. They are reliant. And you can also see what other companies have been working with the trading company. So you have better assessing points. And another case study I can give is like this exclusive distributor was trying to take over. What I'm saying is, sorry, 1 second. I made a note on my slide. Yes, I have it here. So I've also observed these tricky attempts in the exclusive distributor of my former clients. I was there, so I could prevent my client from being deceived. First, the exclusive distributor offered to make the terms of service and privacy policy for the Japanese customers on behalf of my client. They made it in Japanese and provided a reference English translated version. They emphasized that it was made from a very standard format and nothing special. and they demanded my client to approve within some hours because the online release was approaching. That was their reasoning. Luckily, even though it was already past the normal Japanese working time, like it was after 6 p.m. in Japan time, I was actually physically with this client, so I could spot it and I could just run my eyes through right away and found that there was some substantial differences between the Japanese original and English reference translation on how they describe the distributor's role and entitlement. And another weird attempt from the same distributor was when they urged my client to allow the distributor to register for client's trademark in Japan through a domestic registration under their name, not my client's name. They again said that it is easier to do it in Japan and the Japanese lawyer can prepare the application document quickly for free of charge. It is very possible for exclusive distributors in Japan to register for trademark of their client's products, brand, and logo. However, when the registration is done solely under the name of the distributor, and if the distributor refuses to transfer the trademark ownership after the distribution relationship is ended, then your company will no longer be able to use this trademark name or logo or the brand name for your own purpose. And domestic registration in Japan is not easy. It actually takes a long time to process and the fee is high. It was a Japanese conglomerate which proclaims to be using English as the operational language. And in such an environment, I would say it was unbelievable that the legal department didn't know about the international registration way, which was actually a lot easier. Those in-house lawyers were either rather underskilled or hyper clever and pretending to be lost in translation. But by all means, we couldn't trust their lawyers. It is very important that you know how to protect your intellectual property rights. The easiest way for you to register a trademark in Japan from Estonia is to do so through the Madrid Protocol. It's all in English, cheaper and faster. Do submit it before your product becomes well known. I can't see any good reasons, but if you really want the distributor to register your trademark in Japan for some reason, then please do it as a joint holder registration, meaning that both of your company name and the distributor's company name will be on the trademark registration as a trademark holder. This way, you can still reserve the right to use your trademark even if the distribution relation ends. Another thing, patent registration in Japan is also extremely difficult if you do it through the domestic registration way. So if you have more than 3 countries to register, but we have to exclude the United States in this case, if you have more than 3 countries to register for the patent, then opt for PCR application and search for a Japanese patent lawyer, which is called benrishi, while waiting for the PCR approval. Because after the PCR approval, you need to move on to the domestic registration anyways. So you need someone to help. Domestic process can't be completed without the Japanese patent lawyer in most cases. Lastly, copyright. You would see this C circle mark, all rights reserved in the English version everywhere. But all rights reserved can't be reserved in Japan. What I'm saying is that in Japan, moral rights are not transferable. So, for example, your personnel in Japan may produce copyrightable materials, and your company wants these materials and attempts to clear copyright issues around them. What you can do is to have the copyright holder waive his or her moral rights, specifically naming the Japanese copyright law's article number or moral rights, which is I shall not claim or appeal for moral rights under Articles 18, 19, 20 of the Copyright Law of Japan. If you do this, then the moral right issue disappears. But if you don't do this, then the moral rights, these Article 18, 19, 20 applicable moral rights still stay with the copyright holder, which is the initial writer.
So far there's no question in the chat, but I have a question.
Yes.
So for Estonian company, let's say that now they are trying to approach the Japanese market.
Yes.
And then meet the potential company, like potential distributor in Japan. And then now maybe time to sign the NDA.
Yes.
Then you provided template, which is also in Japanese as well. Do they contact Estonian law firm first, or how should they, approach? I think before approaching to the Japanese law firm, I think they should approach Estonian law firm. What do you think?
Okay, so in the world of contracting, there is a power balance. If you're asking for something, then you're weaker. For example, if you want to sell something in Japan, and if you really need a lot of help from the distributor, in which case you're in the weaker position because you're asking for the favor. So usually, also sometimes the counterparts would ask you, do you have the standards template for this type of contract or agreement? But it's very unlikely, especially that your contracts and agreements would be in English. So in most cases, you will end up with the contracts and agreements from the Japanese side. But if you can still pursue to offer your version and let them review, that's also an option. But again, the legal department in Japan is usually small, or they don't even have a legal department. They just rely on the lawyers on the project basis. So if this gives more time for them to think about things, then it will slow down the whole process. So that's a kind of call that you need to make. Do you want to really uphold your legal standards from your own way, risking the, risking the business opportunities in the time duration, or can you wait and do you want to pursue your legal standards? If you don't really have the high standards, and if you can use the checklist that I shared with you to get the gist out of the Japanese version, and if you're comfortable, then that's the fastest way to go.
But so if Estonian company received the standard format from Japanese company, what Estonian company should do now?
I can suggest that you can first start using my checklist to ask the Japanese counterparts to fill in, so you will understand what points you should be specifically looking at carefully. And this is the reason why I'm offering you the checklist, is because when you try to talk about business and when you need the NDA, by this time maybe you're not well prepared with a Japanese bilingual officer. So that's why I'm suggesting to give the burden on translating a bit or giving the guidance for you a bit from the Japanese side. With the questionnaire, it's just easy to follow. It's just either circling the multiple answers or just highlighting on the Japanese NDA. So it's not much for them to do. All we need is someone who can read in Japanese and who can faithfully answer on this question. Yes.
Sorry, my question, but also, are there any risks that if the Estonian company turning to that Estonian law firm and then for help, do you think that the Estonian law firm, are they aware of this Japanese legal matters?
For the Estonian law firm to review the Japanese contracts, it needs to be in English at least, I think. And usually the NDAs wouldn't deviate from the normal range, but depending on your business or the service range, for example, if you have some physical products or prototypes to share, and if the NDA from the Japan side doesn't really envision sharing the prototypes in a physical format, let's say if they say that at the end of the NDA term, all the confidential information shall be erased or removed, in which case you wouldn't want the prototype to be destroyed. You probably want them back. You want them to be returned. And in these kind of cases, you should argue back. And for this, you definitely need someone to understand the Japanese context. And on the checklist, I just also made some guidance points. But again, if the Japanese distributor or the Japanese counterparts didn't righteously answer on the questionnaire, then also there can be some missing information. So it's best that you have someone fully bilingual on your side. And if you want to manage the legal matters in the best way possible, you better find someone who has been educated in law in English context. Any questions?
So you are saying that there is no simple business model with Japan. Like we agree on terms, we shake the hand, they pay money, I deliver goods. That's all. Contract is always needed.
Usually, yes, contract is always needed. And I also observed that some of the Baltic exporters don't even try to make the contract. They just say like, oh, it's just like, you know, a normal shopping. You order it, we provide, payment, done. But in Japan, for this kind of transaction between companies, usually they want to have the contract. For example, if you just buy some air conditioners for your Japanese office, then you probably don't need a big contract. Maybe you have an order sheet which has some terms.
But I can say that some of the Estonian companies who are doing business with Japan, let's say one like Loghouse company, been doing business with Japanese company more than I think 15 years. They don't have agreement. They have like a gentleman, you know, the gentleman shipment, and then they're just doing business. But of course, there's sometimes once in a while problem happen. Why? Like then they kind of argue at the time because they don't have any, you know, legal format. So, but yeah, some companies doing business without any contract.
I'd save some money by asking now, as you said. I mean, it is related, this politeness part, yes? You have to be ready to build a relationship as well. No, it's not purely, as my colleagues are asking, contract-based. Without relationship, you cannot do it with the Japanese partners. But I had funny, but you know, interesting experience. I just tell it, maybe you will guide us in this direction, all this hierarchical and male-female interactions. I was at a conference, it was overseas, and we had a lot of very high-level Japanese officials, professors, and we happened to be in the lift together. We were discussing, and it was, you know, like quite not Empire State Building, but really the building with a lot of floors.
Right.
And I was leaving a bit earlier. They went up before I left because they were a group of older gentlemen. I thought I'm doing a polite thing, and I bowed, and they bowed back.
Yes.
And then I did again because, you know, and they did again. I was
did it go endlessly?
I didn't want to be rude. I did again. They did again.
Right.
And, you know, I was already a bit in a panic, doing all the time, keeping the lift. It's high building, conference. Other people were waiting everywhere, you know, to get the lift. Then I was totally terrified. Handyman is coming. Told what happened. Somebody called, you know, the handyman to fix the lift. They thought something technically happened. And we were bowing. I was nearly hysterical. So the guy told me, you know, like simple working, what bloody hell you're doing here? The whole building is, you know, blocked. People cannot go up because conference. And kind of we stopped, but still, I don't know who should like stop first. From point of view to be polite, you know, not to break the, of course I can just, but not to break the relationship, to have good, you know, this kind of thing. Yeah.
There are some factors. For example, if you were the guest who were invited by them, then you have the better authority in this case. So if you just, you know, do the bow, they certainly would do the bow. They probably would keep bowing until you just disappear from their sight.
They did, but you know, I didn't respond.
And if you did it again, then they have to, you know, raise their head up and do it again.
Like, you know,
yes.
big issues.
So you could just, leave after one round.
But who is still, you know?
But I think in this case, maybe the same in Estonia, that if you say thank you to each other,
yeah.
But then
thank you, no thank you.
But if you say again to me, then I should say again.
Yeah, but you know, in Estonia it's a bit milder because it's such a, you know, relationship.
Sure.
You know, some people are less like, and not that hierarchical, it's more like flat. But there they were really like high rank, you know, elderly gentlemen. So I didn't want to be rude because later we had the interaction. So you mean they should stop? I should.
So usually,
because we continued cooperation later. That was, you know, I didn't want later to have this trouble.
So usually the guest would have the better discretion, and if it was a conference, everyone is on the same level. But it was held in Japan, yes?
No, it was, you know, we were actually in America.
In America.
The third, that's the
oh, then that's really difficult.
Yeah, I wasn't a guest. We were both at the conference,
right.
But they were still, you know, higher by, let's say, hierarchical methods, something sort of ministry.
If we were in Japan, then
trade or something.
You would be considered to be the guest anyways, because you came to Japan, you're a visitor.
Yes,
so they would probably treat you as a guest.
And people are hierarchically higher, and you later meet them, not meet them, but you cooperate later. I mean, it's not just last meeting, then you really don't.
But maybe one round is done. So
one is enough, but who is like
you can probably go because you're leaving, so you have the power to dictate this situation, I think.
So I should like I should once go send them to the top of the building.
Yes.
But regarding this communication, I believe that you know, for Estonian companies, sometimes the company worry about, you know, this communication, like the cultural difference. But what I'm saying is, don't worry, you're not Japanese. Yeah, so whatever you do, they will accept.
Yes.
And then they will not get mad at you.
So later they're not saying,
No. For example, let's say, like in Estonia, if I meet you first time, like can I say kasa, but instead of kaste. But are you angry with me if I'm saying kasa?
But I think in Estonia it's a bit milder those things. You know what's in Japanese culture? It's really more hierarchical.
But Japanese people
are more sensitive.
Don't apply the same values towards foreigners. So when they register that someone is a foreigner, or when they, let's say, when they register me as a person who probably have lived abroad for many years, they also exclude me from their circle. So they treat me differently. And I intentionally just go into that category.
You can stop and they think, okay, she's the one.
Everything is forgiven.
You should act as, you know, normal Estonian. So, and then in Estonian Japan, that we have like a lot of common in this culture. I mean, we don't also like express emotions so much. We don't talk so much also. So just.
Because you know the problem is you need to, not need, I don't know this word, but you communicate later on business matters, so you want to really keep it in a proper way. You cannot just think, okay, but that was total hustle.
Any questions? Okay.
I would say that just like Mr. Yoshito said, Japanese people and Estonian people share a lot of common mentalities. But the biggest difference I see in our communication is this. A lot of times, Japanese people, because they feel guilty for saying no or rejecting, so they don't say it out loud. But in Estonia,
they just say what they really mean. So if the Estonians say yes, then it just really means yes. There is no 80% no, I'm not sure. There is nothing like that. But in Japan, it's really difficult to read between the context, because sometimes they say kento shimasu, which means we're gonna give some considerations on this. For English speakers, when you hear this in English, we're gonna give some considerations on this project. Then it sounds positive, but in Japanese, usually it's the opposite. If they say we're gonna give some consideration, it means we'll take it home to get some time to find a reason to say no.
Actually, sorry, it might be that everything which is not clear, yes, is actually no. I would say this way. Yeah, despite it sounds like that. I mean, yeah.
But also at the same time that because usually in business, when you talk to someone in a Japanese company, the person you're talking, maybe he's in just one team. He has to get the
layers of
layers
approval.
of approval.
Right,
So
right.
he cannot say yes like in the
Not
same
enough,
meeting.
yeah, hierarchy definitely.
Yeah, so he cannot say no, he cannot say yes, so he said he will come back. So yeah, like Yu-san said, sometimes they say, yes, okay, I will consider, but try to get some kind of execution, but sometimes they come back. So, but yeah, it's, this is a cultural difference, but you have to see the face and then reaction, and then you can lead. Then you can lead that what they do. Okay. No more questions? Just in case. Check. So okay, in the Zoom, so there's no question. Well, also we will share that this today's record video later, and then you can check. And then if you have some question later, which is not like a legal matter, you can come back to me. And then, like I said, that Enterprise Estonia, we offer some service that also most of them are free of charge, like a background check. Like today, you learned that from Yuri-san that she pointed out really good thing that don't trust, right away that English speaker, but also we can check together. And then, yeah, so in the future, if you have any questions, you can ask also to AIS. And then if you personally want to some service from Yuri-san, then go ahead.
Yeah, this is going to my LinkedIn profile, so you can contact me on LinkedIn. Yeah.
Okay, and then Yuri-san, thank you very much for today.
Thank you very much. Yes,
okay, and then have a great day. Bye.